First, I think we zero in on what property law is and intellectual property law. That a lot of laws in our culture, in most cultures, deal with property and people's right to property. And intellectual property is one of those forms of property. And intellectual property protects things that are intangible, but that are given value. And they're basically given value both through the law and through the marketplace. So then we start generally talking about intellectual property, of which copyright is one of the branches of intellectual property. And copyright protects expressions of ideas. So it protects things like movies and books and songs and recordings. For people who need assistance in this area or are looking for more information, I would point them to even Donald Passman's book, All You Need to Know About the Music Industry. That gives a pretty good primer on copyright law, the ins and outs of it, and especially how it affects musicians.
Well, copyright, of course, is a couple of areas, because one, you have two kinds of copyrights, primarily in the music business. You're dealing with a copyright in musical composition or a copyright in a phonograph record. So if you want to split the two for a moment, you've got your copyright in a piece of music that you might sit down and write. So there's this song which you either put on a tape or put in the form of a lead sheet of some kind, and that's the copyright in the musical composition. Once you record the song, you've created the song by writing it. Once you've written the song and you now record the song, you have a second copyright. The second copyright is in the master recording or the recording of the song. So you have your two separate copyrights, one in the music / the song you've written, and one in the recording of that song. Now, a trademark deals more with trade names as opposed to copyright, which is what you have created with the song. So they're really two very distinct items. Trademarks, trade names. Example, the Beatles. Okay, it's a trademark. You can't go out and use somebody else's trademark and record under the name the Beatles. You could take somebody else's musical composition and, with a license, utilize or re-record that musical composition, which we would call a cover record or a cover recording of the original musical composition. And they come into being separately or really very differently. In a copyright, when you finish writing the song, copyright comes into being. You can't get a trademark until you actually use the trademark in commerce. So the fact that you might come up with this great name called Kinko's, until you go out and you open your Kinko's store, you don't have your mark in Kinko's. And then when you use it in interstate commerce, you have a store in San Francisco and you have a store in Las Vegas, then you can get a federal registration on your trademark.
The exclusive rights are as to anything that one has created that has sufficient materiality, which is a low threshold. But anything you create, a song, a book, a statute, a picture, a painting, anything you create, copyright law gives you a limited monopoly over how that creation is used. The copyright law was enacted, if you think about it, there's the public policy. There's always a public policy when you have a law. Why are we making this law? And the public policy behind the whole copyright law is, well, we want people to invent things in our societies. That's been judged to be a good thing. We want songs, we want books, we want paintings, we want all these things. Well, how do you give incentive to people to create these things? And the copyright law says, okay, what we'll do is we'll give you a monopoly, with exceptions, a monopoly over how that creation is used. So it gives you, it enumerates 5 exclusive rights that the copyright holder has. That's the right to reproduce the work, the right to distribute the copies of the reproductions, the the right to make derivative works, the right to public performance of the work, which would include television and radio performance of the work, and the right to publicly display the work, which doesn't have to do with music, but has to do with other things. Oh, there are always exceptions. Like I always say to my students, any law can be written, most laws can be written on one page, and then the exceptions are the 300 pages following the one page. There are exceptions to the copyright law. For instance, some of them are historical and are interesting, but not really relevant. The big one that affects music and songwriters is the compulsory license provision, the compulsory mechanical license provision. Now, what's a mechanical license? A mechanical license is the right to reproduce the song in a sound recording. So anytime a song is put on a sound recording, a mechanical license must be obtained by the person recording the song. And that's called a mechanical license. So it has to do with records or recording. So the copyright law says, back to this public policy thing, well, we're giving the creator of the song this monopoly, but on the other hand, what we're trying to do is benefit society by these creations. So maybe this monopoly is a little too tight in this area. So the compromise is that once the songwriter or the copyright holder of the song has recorded the song and distributed copies of that song, of those recordings to the public, then anybody else can basically, in common vernacular, do a cover of the song. And that's the compulsory license provision. That's how I can record John Lennon, a John Lennon song, or a Coldplay song, or anybody else. The compulsory mechanical license does say, well, you can do it, but you got to pay the song copyright holder. So there's a thing called the minimum statutory rate. And right now that's 9.1 cents per song per record. So if I want to do a John Lennon tune, John Lennon's estate cannot stop me from doing anything that's already been recorded, provided that I pay to John Lennon's estate, or whoever controls that publishing, 9.1 cents for every copy I make of that sound recording. Although the copyright law, as you point out, is the background and the backbone of what happens, most people don't go through the compulsory mechanical license provisions of the copyright that the Copyright Act sets forth. Why? Because you got to send money to the Copyright Office every month, and then the songwriter has to get their money from the Copyright Office, and who wants to deal with the government, basically, and the bureaucracy. So over time, what has happened is that someone wishing to do a cover enters into an agreement directly with the publisher, and so there's a lot less paperwork, a lot more control for both parties.
Copyright is a bundle of rights that are given to creators of original expression, largely exclusive rights to control certain uses in that expression. Principally, if the artist is a creator, the artist's principal way of getting money for the use of the artist's creative expression is through copyright, because through copyright no one else can make copies of or publicly perform, broadcast, or publicly distribute copies of the music without the composer's permission. Copyright, as I said, is a set of exclusive rights in original works, although there are, I say exclusive rights, but there are some various exceptions and limitations on those exclusive rights. But principally, the exclusive rights are firstly the right to reproduce copies of the work, reproducing a copy would be in any manner or form, so it would either be in paper or making of a sound recording of a musical composition is the making of a copy of that musical composition. It includes the right to make derivative works of an original work, which would include the right to modify the work, remix the work. It includes the right of public performance, and public performance includes both live performance and also transmissions over the internet and broadcasting. It includes right of public display, which probably is more relevant to graphic works and maybe in some cases literary works and actual works of music. And it includes the right to distribute copies to the public, which is a separate, independent right from the right to reproduce copies of the work. First, let me say that as a condition to enjoying copyright, the composition has got to be fixed in a tangible means of medium of expression. So, if you think of a song in your head and you sing it, you perform it in a studio, or even live on stage, unless you've actually recorded it or written it down, it could be written down on sheet music, or it has to have been recorded, fixed in some tangible means of expression, it's not yet protected, and anybody could copy it at that point, at least as the composer. So, in any event, I would say all of those rights could be important for a musician. So the right to reproduce copies means that once your work is fixed, no one else can reproduce copies of your work. The right of public distribution means that no one can distribute copies of your work to the public. And public distribution has been defined also as allowing others to download copies of your work off of a computer. That's, of course, they define that as a public distribution. Nobody can broadcast your song over the radio or perform your song live without permission. Now, in practice, maybe this is getting ahead a bit, but in practice, most musicians have licensed or assigned at least part of those rights to other parties, maybe to a record label. ASCAP and BMI usually manage the public performance rights for most music. So when a radio station, for example, plays your music on the air, they generally do so under a license with ASCAP or BMI, which gives them the right to publicly perform your song. And they pay a certain percentage of their gross to ASCAP and BMI, and ASCAP and BMI divvy it up to their various members in accordance with a sort of formula that they keep pretty much a secret. Generally, the music publisher governs the right to distribute copies of your work. And distributing and making copies, it's called the mechanical rights. Mechanical rights is making copies of your work. And the music publisher will often go out and try to find people that are interested in recording your song. And that may involve recording artists. It also may involve record labels. So the music publisher administers typically your mechanical rights. Now there is, then the record label, if you are also a recording artist and you want to record your song with the label, very often the labels also have music publishers that are affiliates. And sometimes if you don't already have a music publisher, the label's music publisher will then administer your mechanical rights. And then there's also a performing rights society, which includes principally ASCAP and BMI, and they administer the public performance rights, which includes both, as I mentioned earlier, rights to play your song over the radio, as well as live performances, and also the rights to play your song over the radio in retail establishments, bars, and restaurants.
Think about what Weird Al does. He's not really making fun of Michael Jackson when he says, eat it instead of beat it. He's actually trading on Michael Jackson's song and reputation and all that stuff. Changes the words in a humorous way, but he's really not criticizing generally Michael Jackson or in any of these other parodies. My understanding is that Weird Al goes to copyright owners, Michael Jackson or whoever else he's done done these works, and he seeks a derivative work license. And if we go back to our discussion before, making a derivative work is a exclusive right granted to you under copyright law. So we didn't really talk about that before, but a derivative work is, I think a good example of it is somebody writes a book, and then MGM wants to do a movie of the book. The movie is a derivative work of the book, meaning the movie is based on the book, but it's its own creation, really. You can't make a derivative work, a movie of the book, without the book author's permission. And so Weird Al views his creation, shall we say, in the same way. He goes to the copyright holder of the song and says, hey, can I use your song and write new lyrics? And the copyright holder can say yes or no. No compulsory derivative work license. Say yes or no. And usually that rights holder of the original song will be asking for an income stream from Weird Al. 50-50, I don't know, 60-40, whatever it is. Now Weird Al could take the position that it's a parody, but he'd probably spend a lot of time in court. So I'm sure he and his advisors have decided that it's better to upfront decide there's no problem, enter into an agreement with the original songwriter, and call it a day. Public performance. Do not be fooled into thinking it means that only you can play your songs out in public. It sounds like that, but really what we're going back to the exclusive rights. Public performance is one of the exclusive rights given to you. So that means basically anytime there's a public performance of your song, you have to agree to it under copyright law. That can get a little heavy in transaction costs, as you can imagine. The radio station isn't going to call you every time that your song is played. And the TV station. Theoretically, you could prevent a radio station or a television station from playing your song. But in my experience in the last 30 years or something, people are falling over each other, clawing over each other to get their songs on TV and in radio. So what happens is that television stations, radio stations, Gap stores, malls, auditoriums, bars that play music, etc., anywhere that music is played to the public, have to pay for it. They have to pay the song copyright holders. Okay? And how is this accomplished? It's accomplished through the public performance societies. In the United States, those societies are ASCAP, BMI, and CSAC. And so how does this work? Okay, well, I write a song, and I know it's going to be on the radio and on television, or at least I hope so. I join one of these societies. Let's say I join BMI. I become a member of BMI. And besides me, there's 100,000 other people, or 200,000 or 300,000 songwriters who have also joined BMI. BMI then goes out on behalf of all of us, and they go to every television station and radio station and Gap store and nightclub, etc., and they say, hey, you're playing our music publicly. Please enter into a license agreement with us. We'll set a fair fee, and you will pay us. BMI collects all the money, puts it in a pot, and then tries to guess. No, tries to give out to its members the money proportionally. So if my song is played on the radio, I actually got a BMI check when I was a musician. We got a lot of radio play, say in the Boston area, and I got a check for $7.81. That same year, REM, for their songs, probably got a check of $781,000 in change. So it depends on how many times your song is played. And it's not an exact science, but it's extrapolated from the information. Think about when your album comes out and a reviewer, should you be so lucky, is reviewing it in Billboard or in Rolling Stone. That reviewer might say, well, let me talk about some of, this songwriter is a great lyricist. Not so hot about the music, but some of the lyrics are great. And they want to give an example of what they're talking about. So they would write out one of the verses and the chorus of the song. If we go back to our exclusive rights, that person doesn't have the right to reproduce those lyrics. Because by putting them in the article, that's a reproduction. Therefore, that would be a violation of copyright law. Well, we have a First Amendment and we have this public policy. We want people in the society to talk about these works of art because that contributes to the societal discussion. So the fair use exception says it's really a balancing of First Amendment rights and this monopoly that copyright gives you. So the fair use exception says in certain instances one can use a small portion of the work for certain purposes. And those purposes include for purposes of criticism, like our critic at the Rolling Stone, for purposes of education, like I might be able to publicly display, which is one of the exclusive uses. I might be able to publicly display a painting in my classroom as part of my lecture on copyright. Without this fair use exception, I wouldn't be able to display that work. So fair use is First Amendment and the monopoly. And the other big exception that people talk about under the fair use is parody. But really, when you think about parody meaning, what does it mean to parody something? Make fun of something. But so some people think of Weird Al as being a parody, but we'll talk about that in a second. But I think parody really is part of criticism. So, for instance, I shouldn't have even brought up Weird Al, because what Weird Al does is really, if you think about it, not really parody. Parody is using something and making fun of it for the purpose, usually, sometimes just to make fun of it, but really the message is a criticism of either the author or the work itself, or what the work is saying, what the message of the work is. So that is a fair use thing.
One of the important exceptions that many people have heard of is the exception of fair use. If someone falls within the category of fair use, then they are allowed to make use of your work without any payment to you and without having to ask your permission. But fair use is a fairly narrow exception, and it's difficult to predict ahead of time whether or not a use will be considered to be a fair use. Another limitation, though, to the exclusive right, which affects musicians across the board much more frequently, is what's called the compulsory license to record your song. If you've written a composition and your composition has already been recorded and released to the public, anyone else is entitled to make a cover recording, their own version of your song, and they don't have to ask your permission. What they do have to do is pay you the statutory rate set forth in the Copyright Act. And usually, even those mechanicals are administered through the Harry Fox agency, which represents music publishers. Right. If your cover constitutes a fair use, then you don't have to get permission. You don't have to pay anything. It's very difficult to determine in advance whether a given use is going to be a fair use or not. Fair use is designed to be an equitable rule of reason that courts are supposed to decide on a case-by-case basis whether it's fair to allow someone to use your work without your permission. The Copyright Act sets forth 4 statutory factors that are supposed to serve as guidelines for the courts to consider in determining whether or not a given use is fair. And those factors aren't exclusive. The court can consider other factors as well. Those factors include, probably the most important of those 2 factors are, first of all, what is the nature of the use? If the use is transformative, such as if it's a parody or criticism, that tends to count in favor of fair use. And then the 4th factor is the effect of the use on the market for the work. If the work is going to substitute in the market for your work, if it would compete with your work, then that will count against fair use.